that the Deputy President of the Republic of Kenya is a high-ranking state official. The Republic of Kenya, the polity of the Republic of Kenya is based on certain fundamental national values and principles of governance. In addition, there are provisions on leadership and integrity. If you look at the provisions of Article 75, starting with 73, then you conclude with 75. There is an express prohibition on conflict of interest when it comes to all state offices. Now, to contextualize that question, you have to look at the purpose of impeachment. The Deputy President, being a high-ranking state officer, means that there is a constitutional process for bringing him into account to question his conduct. And that is why you have this process of impeachment. Impeachment is about political responsibility. It's about governance. Impeachment is not about criminal culpability. It's not about gathering evidence for purpose of taking him to court. It's about bringing him to account on what he has done from a political standpoint, and that issue of the distinction of criminal processes from impeachment has been clarified by the Supreme Court of Kenya. The Supreme Court of Kenya, in the case of Mike Sonko, was expressed clear and unequivocal that impeachment is about those values, ethos in Article 10 and the provisions of leadership and integrity in Chapter 6. Now, if you look at the way ground number 11 has been coached, ground number 11, Mr. Speaker, sir, ground number 11 talks about gross misconduct. Now, the Supreme Court of Kenya has interpreted what amounts to gross violation, which in context then means gross misconduct. And the conclusion is that when you violate these core values in Article 10 and the provisions of leadership and integrity, then you are guilty of gross misconduct. You are guilty also of gross violation of the Constitution. Sometimes you are guilty of abuse of office. So to put it in context, if you look at that charge that we have put in ground number 11, it talks about bullying of KEMSA officials. Now, that fact of bullying, and we have been more specific. If you look at the charge, we have mentioned the specific clause of legislation where the act of bullying has been prohibited. And this provision, if you look at the provisions of the Leadership and Integrity Act, the provisions of the Leadership and Integrity Act specifically prohibit bullying of bullying by state officials. And in that context, then you can see that in terms of the allegation that we are making and the evidence which has been submitted before this House, especially that call which was made by the Deputy President. The call was made by the Deputy President to a KEMSA official. Why would the Deputy President be pushing the interests of a commercial, the commercial interests of a private company? That is crystal clear when you look at his own admission in his response to this allegation. The Deputy President has admitted that he lent the sum of Kenya shillings 200 million to Crystal Company to acquire some hotel in Nyeri. This is the same company which the Deputy President is making a call to KEMSA to consider. And a senior KEMSA official, in this case the managing director, goes to EACC in a tender process.
Mr. Speaker, I was just wondering which clarification my learned colleague is responding to, because the time for submission is in the evening.
Yes, Counsel from the National Assembly.
Yes, Mr. Speaker, sir, I'm just concluding that it's an impeachable offense to make the link.
Very well. Now conclude.
Yes, so, Mr. Speaker, sir, if you look at then the evidence which has been submitted by Dr. Mulwa, that he received a call from the Deputy President, who is a high-ranking state official, to go to ES, and then he went to ESCC to collect evidence which EACC had gathered for purposes of submitting that tender to the deputy president or his conduct, in this case, his son. Then what we are saying is that that act by the deputy president then constitutes a violation of the provisions of the Leadership and Integrity Act, specifically Section 34 of the Leadership and Integrity Act, and that amounts to bullying. And to that extent, we are submitting that charge has indeed been substantiated in all its four corners. On the second question, and here again, it appears there is a misnomer. To prove an economic crime, you don't need to prove that there was loss of funds. An economic crime in this case occurs when a sitting deputy president, in a tendering process, he makes a call, which the recipient then interprets in a different way, perhaps to influence the tendering process, or perhaps to for certain decisions to be made in favor of that person. And the person who is making the call is a sitting deputy president. That is why then the provisions of the Constitution prohibit
Mr.
conflict
Speaker,
of interest.
sir, if you may, I think my learned friend has enjoyed a lot of latitude in respect to responding to issues that were not sought for clarification. I was taking note of all the issues that were sought. And the issue that Council is responding to are not among those that were sought. And if they were, then you need to indicate from which particular senator did seek that.
Council for National Assembly, reserve other matters for submission.
Yeah, Mr. Speaker, so I'm responding to the question of whether there was loss of funds.
That was not sought for
It was
clarification.
sought by a senator. And,
It was sought.
It was sought.
It was sought.
Yeah.
1 minute.
Yeah. So, Mr. Speaker, sir, in this case, evidence has been led. If you look at it from one perspective, evidence has been led by Dr. Mulwa that indeed there was a delay in this procurement. Secondly, fewer nets were supplied. Thirdly, there was a question concerning the costs incurred in this tendering process. And the evidence was that 55 million shillings was incurred in this tendering process. It came from the mouth of Dr. Mulwa. So to that extent, you can see there was some loss. Whereas the tender was financed by the Global Fund, from our own perspective, we lost a lot, not only from a monetary perspective, but also from the other factors. What about Kenyans who did not access this malaria, these mosquito nets and were exposed to malaria? Is that not a loss which is non-monetary, and therefore, to that extent, one can make a conclusion that the conduct of the deputy president in this regard violates the provisions of Section 34 of the Leadership and Integrity Act. Mr. Speaker, so I end by stating that we have fully substantiated ground number 11, and it's one of those grounds where the evidence is clear, conspicuous, and there is a nexus to the deputy president himself through a phone call that he made to Dr. Mulwa, and he has admitted making that phone call. Thank you.
Thank you. Now, Honorable Senator.